Yeah. 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 So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit of conflict or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge they don't know they missing. Got a couple current events that you like, wanna know about law from the eyes. Tired of all these blogs running lies because their agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
Good evening, everyone. My name is Pam Esquire, also known as Your Law Intellect, and I'm going to start out telling real as it gets. I'm glad that you found the channel too. If you are new here, welcome. If you've been here for a little minute, welcome back. I appreciate all of the support. Many people ask how they can support the channel. The best way to do so would be to hit that like button on your way in, subscribe to the channel, and tell Lottie, Dottie, and everybody that we are on breaking down legal news from the neighborhood to Hollywood. And yes, we are back. We were just here a few hours ago because we had a night court last night. We were on at a good midnight, the Eastern Coast time. And I guess we were on West Coast time because they're a little bit earlier. But yeah, we were on 12 o'clock my time till about 2 o'clock. And we talked about Russell Simmons, and we also talked about this grimy lawsuit, just nasty, with country singer Garth Brooks. So if you missed that last night because you were sleeping, you were slumbering, you were getting your beauty rest, you were resting your intellectual mind, then I want you to go back and please watch that video after we get off of this one. Welcome to all of you guys. I see you guys coming in. I don't know what it is. I keep saying I'm not going to talk about Diddy, but then something else happens. So we all know that Diddy, Sean Combs, has been fighting. He said he is not going to. I thought I told you that we won't stop. He is putting up a fight to get up out of jail. And I understand because it probably is very difficult for him to help craft his defense being locked up. And so, as we reported before, he decided to expand his team. So he didn't just expand his team from the district court level, from the trial court level. He's also added an appellant attorney, and that appellant attorney filed a notice of appeal. I believe it was on October 1st-ish, where she filed a notice of appeal over there in the Second Circuit. And her brief, the brief that she has filed, was filed on today. So what I will say, I have not read the entire document, but what I will say is, sounds like he made a good decision. I know that people have their own personal feelings about Diddy. And I wasn't too fond of him after that cheesecake incident. I've been mad ever since. I probably should get some therapy because I felt that it was just so wrong and I just didn't like it. Didn't sit right with me and I wasn't feeling him, since then. And I know it was reality TV and I might have just took it too personal, but it was, a couple of them people on Making the Band was from Detroit. And I feel like we are a family. You know what I'm saying? If you're from Detroit, it's like a kinship thing here. So I was a little irritated. However, as a legal professional, I know how to separate my emotional feelings from the legalities of it all. And from the legal perspective, Sean Combs, just as Joe Blow on the street and Mr. Smith to the right, everyone deserves a zealous defense and advocacy. So his defense attorney, from what I've read, the 1 or 2 pages, his appellant attorney, her name is, what's her name again? I know it's Shapiro. Her name is Alexandria Shapiro. She's a good writer. Whoever wrote this, they were doing their thing when they was up there, typing and all of that good stuff. You know what I'm saying? So what I read, I can appreciate a good brief. I can appreciate the time that you put into the brief. And she's done this in a short amount of time, actually, because what's today? The 8th? So yeah, shout out to her. But anyway, she says she is going to keep trying. She wants Combs to be out pending the decision of the appeals court. But he wants to be out. She gives the reasoning as to why he should be out on bond. And we're going to go over there. We're going to go over that. And I want to see if you guys think that this is a possible better argument, or if you guys think that she, based on applying the facts with the law, not your emotions with the law, but your facts with the law, that perhaps the Court of Appeals should consider letting him out on bond. Okay, can you guys just open up your minds for me? I know it's hard. I know it's hard. I understand. But we are the social media jurors, okay? And we are going to think from our intellectual legal perspective when it comes to this as much as we can. So we're going to go over this brief. But before we get into that, hit that like button, okay? Subscribe to the channel. We want to get in this algorithm so people know that we're on. But aside from that, did you guys see that? Okay, so Jaguar Wright. Before we get into Diddy. So Jaguar Wright, we know, went on Piers Morgan, made a lot of these allegations, and there has been a lot of talk and whispers about Jay-Z and Beyonce, right? And Jaguar Wright went on Piers Morgan, which is pretty much a national-based platform, and made some very egregious allegations. Basically said that Jay-Z was worse than Diddy. Then threw Beyonce in there as a cherry on top, okay? Well, it looks like Piers Morgan hey, good vibes only. Jeez. You said I can't do it. Keep them locked up before I even hear the brief. Oh, no. Come on, y'all. We can do it. I got faith in you. I really do have faith in you guys. I do. I got faith that you guys can be, you can be unbiased and just look from the legal lens, okay? And look at the facts and the law and see if you can get with this argument that this attorney is set forth. But anyway, before we get to that, Piers Morgan has now basically apologized. Okay, check this out. Check this out. Let me see. Hold on one second. Maybe I should. Let me see. Okay. And I was wondering when this was gonna happen. See, Jay-Z and them don't say much, but when I seen some of the things that were being had, I knew something was gonna happen. But it doesn't make sense to sue people that are uncollectible. And then a lot of times you bring more attention to the situation, because if a Jay-Z or Beyonce sues a Jaguar Wright, you know how big that would be? We would all be talking about it, and all of that. So you bring more attention to it. So they used a different strategy. They contacted Piers Morgan and said, listen, bro, all of this stuff she said is a whole lie. And I'm going to need you to take that down. Okay. You can keep up the rest of the segments if you choose to. But when it comes to me and mine, I'm going to need you to take that down. Okay. And let me see if I could play it. I'm going to just play it.
Well, Jaguar Wright unexpectedly made several serious allegations about Jay-Z and Beyonce during that interview. As I said in the moment, they were not present to respond or defend themselves, but now they have. Their lawyers contacted us to say that those claims were totally false and have no basis in fact, and we've therefore complied with the legal request to cut them from the original interview. Editing interviews is not something we do lightly at a show called Uncensored. But, like the proverbial cries of fire in a crowded theatre, there are legal limits on us too. We apologize to Jay-Z and Beyonce.
Did y'all hear that? Did you guys hear Piers Morgan say, I apologize to Beyonce? Now, he did say on there that they're not there to defend themselves. He doesn't know if the allegations are true. He said all of the good catchphrases. However, Jay-Z's attorney said, I'm not the one or the two. I am going to need you to cut that totally out of your interview. And I'm going to need an apology. That's what had happened when it comes to the Jaguar Wright, because that was explosive. Like, everybody was talking about that interview. And I think part of the issue why Jay-Z's attorney felt like that had to be done was because back in the day when Jaguar Wright first started making a lot of these allegations, people were listening, but they weren't listening. Like, a lot of people were like, something's wrong with her. You know, she ain't all the way wrapped too tight. You know, people were making all type of statements regarding her. Now, you did have some that listened to had her on their platforms and she gave all these stories or whatnot. But then she had a bunch of other antics with it. And so people were questioning, her mental stability. So, of course, when all these allegations come out with Diddy, people are like second guessing themselves. Like, ooh, maybe it is a lot to what she's saying. So these allegations against Diddy has somewhat given her credibility. So because it's given her credibility, now things that she says after that, I think people are paying attention to, because they're like, well, she did say those parties got a little wild. She was saying this for a long time. She was saying this. She was saying that. Some of her stuff was being corroborated somewhat with the bodyguards and all of these other people that have come out. So because of that, I think that, Jay-Z and his wife, they did the right thing and was like, yeah, you're going to have to take that down. Ain't none of that true. And that's not going to be enough, because all the people, the hundreds of thousands of people that have watched it already, they already saw it. So you can't unring a bell. So I'm going to need you to do a whole separate video of which you apologize. And that's what Piers Morgan did. So Jackpot said it should have never aired. Yeah, because I'm pretty sure it was pre-recorded. So yeah, she talks about everybody, okay? Oh, Ebony said, I'm seeing ads on my timeline for a law firm asking if I've been affected by Diddy in any way. That's crazy to me. And that's crazy to me. It's so many unanswered questions that I have. So, like, another allegation that was going on was that there is an allegation that the baby oil had some type of substance in the oil. And so allegedly there's supposed to be a lawsuit that comes out momentarily by the same attorney that came out talking about the catch and kill and shopping the tape. And she made an allegation that her client said that some oil was doused on her. I don't think she used baby oil, but we know a lot of people are going to infer and assume that's what it is because of all the oil that was found in his house, and that it was thrown on her and then she just went limp. And I guess that's supposed to be as if she was drugged or something. So that's the allegation. But then I was just immediately thinking, so if he's throwing baby oil that has things in it that can incapacitate you like that, like, is he wearing a leather suit or something to cover himself up? Does he have like a full body condom on? Like, how is he avoiding this same oil that he is putting on all these people? But that's just how my mind rolls, So I just don't believe every little thing that comes out. Just like I said yesterday with the videotapes. So even at the white party, half the women that was working there didn't even have clothes on. You know, they had clothes on, but you know what I mean. Like they had skimpy clothes. And even in the lawsuits, they talked about the ones that work in the white parties, and one of them was saying how they had to have a little bit of clothes on. And I'm like, how do all these people got cameras where they're texting these alleged videos they took on their own phone to other people? Because typically they tell you they're going to take your phone. There are some that require you to even show ID, or they have your ID while you're there. So this is a lot of questions I have, just because of how, somewhat knowing how a lot of these celebrity circles move when it comes to a lot of these gatherings when they let people into their space. But Golden Child said, why did I picture a water slide and Diddy sliding on the baby oil slide? I don't know. I don't know why you had that picture in your mind. So you painted a picture of a slide, a water slide, but the water coming down was really baby oil. Is that what's happening, Golden Child? Is that's what's happening right now? I'm just trying to understand. I like every comment deserves some type of commentary. I mean, we need a back and forth dialogue. And all deserve. I just want to make sure I'm understanding what you say. Tracy said the white party was featured as a Vibe magazine exclusive. The photo and videos might be more professional than person. I would agree with that with the white parties, because they were like on the cover. I mentioned that yesterday. Those were exclusive, like how People Magazine does it. But what they also do is most of the time they have them sign certain documents like NDAs, and they can't take pictures and they can't take videos when they have those type of exclusivities in those parties like a Vibe magazine. And the reasoning is, if they are the exclusive entity, I can't go in there with a camera and start taking pictures and posting it on Instagram. So for instance, it was something with Kanye and Kim Kardashian. I don't know if it was a baby shower. It might have been their wedding. I don't remember. But somebody had the exclusive to it. So they all had to sign something saying that they wouldn't take pictures, videos, all of that before they can come and participate, or, you know, witness the nuptials or whatever was going on. Well, somebody decided they were going to take a picture and they were going to put it on Instagram. Of course, they got sued for a whole lot of money, and Kim and Kanye won. So I do agree with that, that oftentimes there's so many, like I said, different parts. So it'll be interesting on where Diddy, if he's able to with incidents such as this with the white parties, what if there are like contracts and NDAs when people walk in and they tell them like, you can leave right now or whatever. It's just a lot of stuff we don't know. That's all I'm saying. You said, I'm going to believe Vibe magazine is probably in the there was one of those lawsuits, actually, Ann Mason. There actually was one of those civil lawsuits. I believe it did have Vibe magazine in it. I can't remember which one because I've been through so many of them, but I believe Vibe was actually sued in one of those lawsuits. A Sunshine said, aren't NDAs null and void when it comes to crime? Well, that's if you're proving that there is an actual crime. We're talking about the white. I'm saying in general, a lot of these parties, before they even let you off the street or anybody come in, they make you sign certain documents. And sometimes they will make you, like, you can't take pictures, you can't have videos. They take your phones. It's concerts you go to where they tell you you can't have phones in there. You can't take your phones out or you get kicked out, like concerts. So it's not unheard of if that happened. But we're also talking about the 90s, like I was saying last night. We were like more in the beeper era. A lot of us didn't have any phones. That's why I'm just curious. And I'm just speaking of the people that saying they personally have videos. When Jaguar Wright was on Piers Morgan, she basically said she had videos or she seen videos. And she was saying some of the workers, I guess she's alleging that were there, they had videos they were secretly recording. And I'm just wondering how all of this stuff was happening, because usually that's why Diddy has security like that. So I wonder if the security, like a Gene Deal, because I haven't watched everything, if a Gene Deal or a Roger Bond would say, like, nah, we made sure people didn't have cameras, or that you couldn't take photographs or you couldn't take videos. So, and then another thing, like I said, that I'm interested to know is, why would Diddy keep this type of information knowing that he's under knowing he's under investigation, and you just had it just sitting there on all of your devices until the feds came? You just were like, whenever they come, we'll just keep them right here on the hard drive and you just come get it. There's just so many questions that I have. That's all. MZGMTSM, it's me. You would need a scientist to determine if a drug was in the oils. If you think about the mixture of oil and if it would break down the drug, this issue is getting crazier and crazier. Yeah. But I think people want to believe. What happens is when you don't like someone, you want to believe the worst about them. You might as well be honest. You people that don't like somebody, when you hear somebody that did you wrong or that you don't like, and you find out they slip and they broke an arm or something, you got a little smirk in you. You know what I'm saying? Sometimes you just want to believe everything when you think somebody is bad. And that's a dangerous zone to be in. You got to be open-minded. We only know what's out here on these YouTube streets or what's in social media. We don't have all of the information. Now, we do know that the feds usually don't come. When they come, they come. Okay. They are the most patient people I have ever seen in my life. They will be investigating you for 7 years. Okay. And they don't have a problem sitting back and waiting on that moment so they can have 4 pieces of corroborating evidence for every single allegations that they have. That's the type of patience that they have. They are not in a hurry. They see some people looking like this YSL stuff over there in Georgia. Everybody is not the state of Georgia when it comes to this. The feds, there's some very patient people, and that's why they have a higher rate of conviction, but they also have even more higher rate of people that actually plea. Most people plea. So call me. Tanise said the attorney kid doesn't really seem like an attorney. She doesn't speak like a real attorney. Her website looks bootleg. She is an attorney out of Florida. And she actually was on Tasha K before, because many of you guys probably don't recall, but she actually sued Trey Songz. And that case is still pending in Miami. And it was some stuff that happened in that case where there were some allegations of her they were alleging some things against her and contacted the bar, and it was hearings. It was all type of just crazy stuff. There was one with Chris Brown, and I believe the girl came out, or Chris Brown came out with some receipts showing something about consent or something. So that ended up being dropped. So she didn't go pursue the one with Chris Brown. There was one with a rapper called Duty Low. And with that case, that was the one where the girl was accusing him of being inappropriate with her child. So she sued her for defamation. And the girl was pro se, like she didn't have an attorney. So the first go around, it was some type of allegation of, anyway, they got an $11 million judgment, but then that got set aside because of some alleged shenanigans. And then they did retry the case, and she went against, like, the girl that was accusing Duty Low of this was pro se. And so this person, Miss Mitchell, was the attorney for Duty Low. So I think she did beat the pro se person in trial or whatever. But and then I think there was another case of Conor McGregor that kind of went away. I believe it was McGregor. It was something about a demand letter. You guys refresh my recollection, where there was some demand letter or something that she put out, and I don't think that really went anywhere because it was just a demand letter. I don't think it was ever a complaint filed. And then even in this Diddy case, she is the one that represented Miss English, and she's filed a motion to withdraw out of that case. And she's basically saying that I guess Miss English wasn't listening to her or doing the opposite of what she said, and she was mentioned about disrespect and all type of stuff. So I'm kind of familiar with her being out here on some of these cases. So she's actually not, she's trying to withdraw from that Diddy case that she's in. But allegedly on these platforms, she has said that she has someone else that is accusing Diddy of some allegations, and she will be filing a lawsuit on their behalf. So hopefully this lets you guys know who she is. Hey, Pam, we appreciate you. Thank you, Springflower, for the super chat. I appreciate it. Let's see. What questions we got? Sonia Mila, it's fine. We're just, we're just doing recaps and summaries on what's going on YouTube. We have not went over the actual document. Okay. A Sunshine said, in my humble opinion, I think he kept something because he thought he was above it all. They wouldn't truly look, or he could buy his way out. Well, baby, that is a big ego if you think the feds ain't going to come for you, because they do not discriminate. You know what? Shay B said, I wouldn't be surprised if Gene Deal show up on Sesame Street in a full-blown interview. And you know what? And that's another thing too, is all of these people that have all this information. I said this before. I'm like, so y'all was watching some of this stuff and nobody said, well, let me try to do something about it. Now, allegedly, there were some police reports that got swept under the rug. But honey, the feds, usually you can call the feds. They're different than your state, local police. And they think that it's might be a big case like what this Diddy case is. I think if people actually contacted the feds, that's what I want to hear. Did anybody contact the actual Fed hotline as opposed to the NYPD? Because the stuff you guys are alleging should have went to the feds. Thank you so much, T Rain, for gifting a membership. I appreciate that. It's Janet said, it's being said that Tony Busby works for Diddy and those claims will never be processed. You think so? Oh, this is getting too deep. What? I've never heard of such a thing. So you think the attorney who went and did a press tour that these people are imaginary and he's really not going to file these claims? How does that benefit? In your opinion, how do you think that benefits Diddy for him to come out and say some of you work for him? That's not clicking for me, because he made even more egregious allegations, because he mentioned minors. That's even worse than the indictment. That math ain't math. And see, that's why I said you have to logically think about and analyze some of the claims that are out here, because you're going to get a lot of clickbait. People are doing this for clicks and views. That's why until I have something substantive to actually discuss, I don't just jump on, because and then if I see the same thing 50,000 times, I don't really talk about it either, because it's like, I want to bring something, I want to bring something of some substance. I'm not just gonna, ooh, that sounds good. Ooh, I see a picture with Diddy with Aretha Franklin. Aretha was at the party. I mean, everybody was at the party. Okay, we've all come to the conclusion that pretty much everybody was at the party. It was layouts in the magazines. We know that if you were anybody that was anybody was at those parties at that time. That doesn't mean that they was at the after party that they said they had. That doesn't mean that once they said the party was over and people started leaving, that it was some people that chose to stay. Yes, please. Can we please get more likes? We appreciate that. What do you think his defense could be for Cassie allegation? As far as that's real general. I think we pretty much know what his defense is going to be. He was in a relationship with Cassie. He's saying that that was a toxic relationship. They did things to each other that they regret. When it came to the video that we saw that was from like 9 years ago, I believe there was a story that he said behind that she had took all his clothes and she hit him first with an object or something like that, and he was running after her. I mean, we've kind of heard, what he's just gonna say it was a toxic relationship. And then also about that she came to him and was when she said, I'm going to put out my memoir, and said, if you buy this from me for $30 million, I'll give you the exclusive rights. And when he said no, she came out with these allegations, in a complaint. So of course he's going to say it was a form of extortion. So I think we could kind of generally figure out what he would say against any allegation specific towards Cassie. The indictment didn't name who the victims were. I think who the alleged victims were. I think that we can conclude, because we've read a lot of these complaints, on who they were referring to. Thank you, Forever T, for gifting a membership. I appreciate that. Simply Me said they said Auntie Riri was there for the food. Simply Me, don't do that. Don't do that to Riri. Listen, the fact Aretha came says something, because Aretha didn't come to everything. She had parties she didn't invite everybody to. She was not that social butterfly. Let's just say that. T Rain said, Cassie said, try me. Pretty much. Thank you so much for the super chat. You said, do you think there will be a superseding indictment? If I were to guess, I would say yes. And I think more indictments are going to come down and more people are probably going to be added to it. They were very clear that nothing is off the table. They, being U.S. Attorney Damian Williams, made it very clear, said it was an ongoing investigation. So that means people are still being talked to. There's probably still hearings going on in front of the grand jury, all of this stuff. While everybody's on the internet with, speculating and stuff, they're still boosting their case up. You know what? Spring Flower said Aretha been partying, said she was 3. That's facts. That is facts. She, ever since she was, I don't know if she was 3, but I get what you're saying. Ever since she was a kid, she was seen in some parties because her daddy was a partier, allegedly. Willie J said, I bet Diddy wishes he had paid Cassie up front. Absolutely, because I said the same thing. When the lawsuit came out, I said, I didn't know anything about this book or how many months it had been, but I knew that as detailed as that complaint was written, and then there was a demand attached to it, and it was sent to Diddy. He saw that lawsuit before it came out. Because that's what you do, especially with high profile people that probably would rather it not be filed for the public's eyes. So he was aware of that. And so when I saw it, I was like, why didn't he just settle this lawsuit? Because he settled it within 24 hours. That lawsuit was probably the fastest settlement ever in history. As fast as we read the document, we were coming back to say it's been settled. There was a notice of settlement filed almost as soon as it came out, and we went over the document. All right, we can talk about this forever. We done 30 minutes and we ain't talked about what we came on here for. So let's get into it. This is the appellant motion for pretrial release. You see how pretty that you have to do your cover pages when you go to the Court of Appeals? They have standard fonts. They have standard cover sheets on how you have to present this to the courts. You got certain word counts. You have all of that. As you guys see, we got the table of contents, table of authorities, which has all of the cases and the page numbers we're going to find them at. So let's start with the introduction. Bail may be denied only in rare case of extreme and unusual circumstances, and that's in U.S. v. Barrios. This case does involve, quote, extreme and unusual circumstances, end quote, but none that typically foreclose bail or warrant forcing Sean Combs to defend himself from a prison cell. What is extreme and unusual about this case is that Mr. Combs was detained immediately after he was charged. Even though he has been in the spotlight his entire life, with many of his purported antics and episodes being widely reported in the press and known to law enforcement authorities. Indeed, hardly a risk of flight. He is a 54-year-old father of 7, a U.S. citizen, an extraordinarily successful artist, businessman, and philanthropist, and one of the most recognizable people on earth. The sensationalism surrounding his arrest has distorted the bail analysis. Mr. Combs was not released pending trial, even though he offered to comply with restrictive conditions that would have prevented any conceivable risk of flight or danger. The district court detained Mr. Combs in conclusory, bare bones oral ruling, apparently because of unspecified concerns that he would, quote, obstruct justice and intimidate witnesses, end quote. The government's arguments about the risk of obstruction were based on speculation, resting mainly on untested allegations about communications with witnesses in civil cases and communications initiated by supposed witnesses and not Mr. Combs. The government even claimed his public denial of a former girlfriend's allegations in a civil lawsuit constituted, quote, attempts to obstruct justice, end quote. If denying accusations by civil plaintiffs could justify pretrial detention, the liberty protections of the Bail Reform Act and the Constitution, not to mention the First Amendment, would be meaningless. Throughout the bail proceedings below, Mr. Combs rebutted the government's proffers, but without fact-finding or analysis, the district court endorsed the government's exaggerated rhetoric and ordered Mr. Combs detained. In so doing, the court committed legal error, rejected a plainly sufficient bail package, and violated its obligations under the Bail Reform Act. Mr. Combs is presumed innocent. He traveled to New York to surrender because he knew he was going to be indicted. He took extraordinary steps to demonstrate that he intended to face and contest the charges, not flee. He presented a bail package that would plainly stop him from posing a danger to anyone or contacting any witnesses. Under the Bail Reform Act, quote, liberty is the norm and detention prior to trial or without trial is the carefully limited exception. And that's in U.S. v. Salerno. Mr. Combs is entitled to release under federal rule of appellate procedure and immediate release pending disposition of the appeal under the federal rule of appellate procedures 9A sub 3. How you guys think she's doing so far? Line 9, Josh say, I'm not moved yet. Okay. Miss HLS said, repeating the same BS. Jennifer S said, nope. Well, golly, not the violins. I think she's a good writer. No, I think she's a good writer. You know, as a person that have seen trash writings, I think she's a good writer. Petty Patty said, please support and hit the like, the thumbs up. Thanks. Thank you, Petty Patty. I appreciate that. Can I get into the document? Dang, Brenda. Jeez. Let me guess. You guys are not Diddy fans right now. Like, goodness. And Mason said, I give her a B. Okay. Aunt Natty said, try again. Simply Me said, I kind of think she's eating a little. It's being civil complaints is a good point. I still don't like him. Thank you, Simply Me. That's all I'm saying. As a person that has seen writings, I think she's, so far, we're just at the beginning. Her intro is, it makes me want to read more. Makes me want to hear what she's talking about. Okay. So she's saying the issue she's presenting on this appeal is whether the district court's obstruction and witness tampering conclusion lacked a factual basis and misapplied the law, whether the district court erred in concluding no conditions will reasonably assure the safety of any other person in the community. And the third issue we will be discussing is whether the district court erroneously failed to make the factual findings required by the Bail Reform Act and weigh the required statutory factor. Let's get into the background, okay? You guys relax, okay? Relax. Mr. Combs' actions during the investigation demonstrate that he poses no conceivable risk of flight. Long before his indictment, Mr. Combs took numerous steps demonstrating his trustworthiness and commitment to proving his innocence in this case. Since early 2024, he understood he was the target of a serious federal investigation. Nonetheless, he immediately directed his counsel to proactively reach out to the prosecutors. He subsequently took extraordinary steps to voluntarily surrender and try to satisfy any possible government concern about flight risk. Months before the indictment, on March 13th of 2024, Mr. Combs' counsel emailed the assigned AUSAs to introduce himself and asked to speak with the prosecutors so he could provide information about the case. So he contacted us and said, hey, my name is Mr. Agafilio. My client is Sean Combs. I heard that you guys are, investigating him. I just wanted to make sure you knew who I was. So we did that back in March of 2024. He renewed the request 5 days later. So they ignored that request. And so he tried again. At first you don't succeed, you try again. So 5 days later, he tried again. And the government still paid him dust and did not respond. Thank you, little lady QT, for the super sticker. I appreciate that. On March 25th, 2024, the government executed search warrants at Mr. Combs' residence in Miami and Los Angeles. Mr. Combs was personally searched, as was his airplane. Counsel agreed to accept services of 2 grand jury subpoenas to Mr. Combs' business. On April 1st of 2024, defense counsel took custody of Mr. Combs' passport and advised the government that it would not be returned to him and he would not leave the country. Counsel also promised to advise the government in advance of any domestic travel by Mr. Combs and did so, sharing his whereabouts and travel plans at least 9, 1, 2, 3, 4, 5, 6, 7, 8, 9 times from May to August 2024. You didn't know you guys were a bilingual channel over here. Didn't know that, did you? Hola, ¿cómo está? Mr. Combs also put his private airline up for sale because of the investigation and notified the government accordingly. And he advised that multiple relatives, including his mother and 4 minor daughters, had given counsel their passports. Mr. Combs also paid off the outstanding debt of $18 million on his $48 million home on August 20th of 2024, so it could provide an unencumbered security for any future bail package. During this time, counsel continued conferring with the government regarding its grand jury subpoenas. Counsel withdrew prior counsel's motions to quash, conducted voluminous searches, and produced over 144,000 pages of documents. So initially, when these subpoenas were issued, it sounds like Diddy's attorney filed a motion to quash the subpoenas, which is to extinguish them, get rid of them. So they, that's what he was trying to do. But then he withdrew that request and said, go ahead, search what you need to search. It's fine. It's fine. Finally, when counsel informed Mr. Combs that his arrest was likely imminent, he immediately relocated to New York City from Miami on September 5th, 2024 to surrender. At that time, his counsel informed the government of his intent to surrender, and counsel offered to continually share Mr. Combs' location with the government and asked for a time when Mr. Combs could surrender. Most of this stuff we've heard already. You know what? One of one. Why would you say this? He'd give both what to walk to Junior's right now. You said he wants to go get cheesecake for the band. That's what he wants to do. That's what the band should do. The people, I need Sarah, Chopper, Nez, what's those other ones' name? Babs. All of y'all need to go to the bail hearing and say, Judge, if he apologizes and he walks to go get cheesecake, then we believe that he is not a flight risk. Maybe that's what they should do to spice this thing up a little bit. Okay. Yeah, Dylan. Yes. Freddie. Thank you guys for refreshing my recollections. He was warned, but going after the liquor companies was his downfall. You know, they knew about his private life. Giving that kind of money, never bite the hand that feeds you. That is coming from my cousin, Big C. I don't know why. Big C, not little C? Huh? Miss Cherie said, we not fooling with you tonight. Listen. Ebony said they sell cheesecake in Bali. He didn't get the cue. Russell saw, we went over it last night. Russell saw, first he said Cosby, then he saw R. Kelly, then they was going after the white people like Weinstein and Epstein. He was like, it won't be me. Pack them rats. He was like, I'm out of here, okay? He said the United States of America is not that great. I'm good. And he's been living in his zen ever since. Yo, comprendo los libros de español. You don't have to use the yo. You just say comprendo. When you do the yo at the beginning, we know that it's I. You know, that's why you have the O at the end of comprendo. You don't have to use yo. Okay. Let's go on. Arrest and charges. Despite Mr. Combs' offer to surrender on September 16th of 2024, the government arrested him on a 3-count indictment charging racketeering, conspiracy, trafficking, and interstate transportation to engage in prostitution. The government claims that the core of this case is freak-off activities, quote, which allegedly involve, quote, elaborate and produced performance that Combs arranged, directed, and asturbated during and often electronically recorded, end quote. Mr. Combs believes the evidence will show that to the extent such activities occurred, all individuals who participated were adults voluntarily engaged in consensual relations. I told you guys that was part of his argument. He's going to say that on those tapes, if you see them, and he'll probably say that people that saying that now, let's just ponder this concept. What if his purpose of taping it was because he didn't want people to come back and say that it was non-consensual? So his purpose of keeping these tapes was to show the consent of it all. What if that was the case? What say ye? Because otherwise, keeping these tapes does not make an ounce of sense to me. But just saying, what if that was the point? Like, he recorded it because he knew that people may come back and try to say, and he knows he got money and they may try to extort him. So he's like, I'm going to record this stuff. Now, the problem is if they didn't know they was recording, but that's a whole nother situation. You said no? Okay. That's what I'm saying. People do record to protect themselves. I know it sounds far-fetched. I'm just saying people really do that. I know someone that, got out of a situation because of recording in the criminal justice system. Power Dynamics said, no, the tapes are trophies. Okay. All right. Hey, Val. Got my fan Bam on here. I'm free to be me, said blackmailing people to fund the lifestyle. I don't want to see the tapes. Like, what? Like, that's another thing. Like, why do people really want to see these tapes? Why do people want to, like, what if some of these people on these tapes are consensual? You guys really want to see, like, we want to know who's on the tapes. The only way being freaky is not a crime. Now forcing someone to be freaky against their will or drugging them, that's where the crime comes in. You know what I'm saying? So that's what he's going to have to prove. So his attorney is saying that to the extent, without really saying it's true, because they probably don't even have all of the discovery. So they're saying to the extent, if there are any tapes of him doing things, it's because it was consensual. That's what his argument is. You said VHS. Diamonds and pearls. I can appreciate your honesty. I think I'm going to pass. You said if they find drugs in the baby oil, he's done. Ebony Wood said, I just want to know who's on the tapes to being bad. Really? Passports. Shogun said it's impossible to prove that you were drugged 10 years later if you didn't get a toxicology report within 24 hours. That is a true statement. I think there has to be a lot of inferences and what we call circumstantial evidence, which is not necessarily direct evidence, such as a toxicology report, but it may be an inference, meaning that a witness gets on the stand and says, I took a sip of the drink that someone gave me. After that, I became lightheaded and woozy. I couldn't really control myself. And then next thing you know, I woke up and I was in pain in certain areas and I didn't remember what happened. They can do it based on circumstantial evidence. Oh, 504, you're nasty. She said, I want to know who was the top and who was the bottom. Is that what you want to know, really, 504? How is that going to help your life, sis? You concern me sometimes, you know? So Simply Me said, "Is Puffy on the tapes?" Listen, I don't know what Puffy doing. I don't even know if he owned the tapes. There were some inferences that one of the people, I guess, was on the tapes and it was at Puffy's house and he was there and maybe watched it. So there's been accusations of both. Because I want to say in Cassie's lawsuit, she said these situations would occur, these freak offs, and he would be off in the corner, you know, pleasuring himself. So, oh man, I can't believe I'm talking like this. I am a saved woman. Got me up here talking all this nasty talk. Can't even get around it, messing with this Diddy stuff. That's a very interesting question. So, if there are tapes, will it be viewed during the trial? You know, the reason why I doubt it, first of all, we know it's not gonna be streamed or anything or recorded, obviously, because it's federal court and they don't allow you to record. However, you can have spectators in the gallery who, like what I do, take notes and all of that. But one thing that is very interesting in the protective order that was filed is that they have in there that when it comes to a lot of these tapes that are like this, they are going to like leave it at, they have a certain room, I guess, where Diddy can come and watch and look at it, but he can't physically remove it. So I don't know. I can't say I've ever had any situations, either state or federal, where they've actually played it. So very interesting question. Patty said, if you woke up and walked bow-legged, you probably should have gone and got checked. Willie J said a lot of powerful men are being taken down. They are. And let's think about this real quick. We have all of these lawsuits that have been filed against Diddy. Do y'all think that these women are really about to get money like this off of Diddy? The government was very clear in their indictment that they trying to take everything that Diddy has. They are trying to take everything. They are trying to forfeit everything. And so, because of that, the criminal cases move faster than civil cases. Before any of these civil cases are concluded, the ones that make it to that point, because right now I'm really surprised he hasn't tried to put a stay on these civil cases pending the conclusion of the criminal case, because Diddy can't sit for a deposition. I mean, he would sit there and say, I plead the fifth. Do you live at so and so and such and such? I plead the fifth. Do you how many kids do you have? I plead the fifth. Like, he'll probably sit there and plead the fifth. So really, these civil cases, you're not going to really get a deposition. That's why I feel a lot of these are being filed, because they think that perhaps Diddy is in a position where he just wants to pay people so that it can go away. But clearly, with the number, like, you got somebody saying 120 lawsuits potentially can be filed on top of the 10, 12 that's already out there. Diddy cannot possibly pay all of these people off, and it wouldn't make sense to settle with anybody. Like, if I got 200, if I settle one and I got 120 more, like, what is that? How does that really, help him? Now, at the end of the day, if he is found guilty of anything, they have a forfeiture, and they're trying to take it because they're saying it's a part of the criminal enterprise. That's if he's found guilty. Again, he is presumed innocent until he is found guilty beyond a reasonable doubt, and it's not his it's not his burden of proof. He does not have to prove that he's innocent. They have to prove that he is guilty. Why haven't we seen a mugshot? Because he's in federal detention. He is not in state. Federal does not release phone calls. They don't release any of that. Hence why you had the situation with R. Kelly when the phone calls, when somebody released them and gave them to another blogger, how they got sued. Because those things are typically not released in federal court like they are with state. Shell B said, I seen videos of Diddy taking people's phones before they can enter the boat. Quincy gave him one phone. He said, give me the other one, French Montana said. That's what I'm saying. That is typical of these type of celebrity events. That's all I was saying, Shelby. Thank you so much for co-signing and being my co-counsel on that issue. I appreciate that. One of one said, I'm curious to see how they connect his music and business endeavors to trafficking and RICO. Perhaps, but I just think it's separate from legal activities. Unscrupulous isn't illegal. I think we cannot take away, I think they can't take away that he has produced artists or been a part of the, I mean, you know, you have artists that kind of say Diddy was sitting in the background just like, okay, that's it. But he definitely had the power and he had the money and the wherewithal to get producers, and he had an eye for talent, obviously. And he was a part of some real lucrative music careers from some of these people out here. He really was a part of that. But I think what they're trying to say is as if it sounds like they're trying to overshadow what he's done in the music industry and his other businesses with clothing, and almost make it seem like this ex trafficking or whatever was the real motive or something, which I think could be difficult to really prove. I think he really went into this because he was an intern, worked for free. Like, he has a story of his come up. So I think he really did legitimately come into this music industry. Now, how they're going to intertwine it, intermix it as if this was a facade, we're going to have to sit back and all see. Diamond and Pearl said, if you're giving up your phone, you knew what was up. Yeah, yes, Diddy had the vision, because I've seen a couple of artists that, you know, they were shelved. Diddy shelved a lot of artists too. So there was some that was shelved, and they said like, yeah, we was in the studio and he was like, that's it. That's it. That's it right there. Just like he was showing up on everybody's videos dancing and all of that. So yes, I am, Miss Buckeye, back at it. Thank you for being a member for 5 months. Okay, let's go on. You know, we can talk all day. Make sure you guys hit the like button. It's 1,000 of you guys in here. Okay. Let's go on to the bail proceedings. So now we know that his argument is Mr. Combs believes the evidence will show that to the extent such activities occurred, all individuals who participated were adults voluntarily engaged in these acts. Bail proceedings. Mr. Combs was arraigned on September 17, 2024 before Magistrate Judge Robin F. Tarnofsky and pled not guilty. The government sought detention, arguing that Mr. Combs presented a flight risk, danger to the community, and risk of obstruction and witness tampering. Despite Mr. Combs' robust bail proposal, the judge detained him. Mr. Combs appealed. The district court held a bail hearing on September 18th of 2024. The court began by noting that the government primarily seeks detention based on a risk of flight and the danger of obstruction of justice or witness tampering. The court indicated that based upon the parties' written submissions, its lesser concern was risk of flight, and its bigger concern dealt with the danger of obstruction and witness tampering. 1. The government's proffer focused on an 8.5-year-old domestic violence incident and vague allegations related to civil lawsuits. The government reiterated the indictment's allegation and only vaguely alluded to possible witness testimony and evidence, primarily relying on a widely publicized March 5th, 2016 video of Mr. Combs depicting a domestic violence incident with a former girlfriend called Victim 1 in count 2. The government also mentioned text messages and phone calls between Mr. Combs and potential witnesses, primarily witnesses in civil lawsuits filed against Mr. Combs. The government went so far as to argue that Mr. Combs' public statement that a civil lawsuit was, quote, riddled with lies were attempts by him to obstruct justice. Point 2, the defense rebutted each of the government's arguments. Regarding the March 5th, 2016 video, defense counsel explained that Mr. Combs and Victim 1 shared a 10-year romantic relationship that was often mutually toxic. Counsel noted that countless written communications tend to negate any lack of consent and any coercion regarding their sexual activity, and cited evidence showing a long-term loving relationship that became strained by mutual infidelity and jealousy. The, quote, overwhelming describing their consensual sexual relationship included communications concerning their mutual decision to, quote, bring a third party into their intimacy, end quote. The violence depicted in the March 5th video was entirely separate, stemming from, quote, jealousy, from infidelity 8.5 years ago. Defense counsel cited interviews with a half dozen male escorts who participated in the freak-offs described by the government and confirmed they never witnessed anything remotely non-consensual. Counsel explained that Mr. Combs and Victim 1 both suffered from serious drug problems at the time of the video and subsequently participated in rehab before eventually separating in 2018. Counsel further explained Mr. Combs' communications regarding Victim 1's November 2023 lawsuit. Years after the couple's separation, a lawyer representing Victim 1 demanded a $30 million payment from Mr. Combs in exchange for the rights to tell all book Victim 1 has supposedly written. When Mr. Combs refused, Victim 1 retained new counsel who filed a lawsuit, which was quickly concluded with a large settlement. This prompted a torrent of other lawsuits. Although Mr. Combs communicated with others about the conduct alleged in these civil suits, including individuals the government now characterizes as, quote, victims, at the time he knew nothing about the SDNY's investigation and was not engaging in any attempted obstruction. The government had no response other than to say that Mr. Combs, quote, certainly suspected the possibility of an investigation, end quote, citing his statement he was not supposed to be speaking on the phone. So basically, after Cassie filed her lawsuit, we know that there were several other lawsuits that were filed making allegations against Diddy. So Diddy was getting on the phone like, yo, remember when we was messing with each other? That was something we both wanted to do. And apparently it sounded like perhaps they may have been recording him or whatever it was. But at that time, it was immediately after the lawsuit was filed. So they're arguing he didn't know he was under investigation by the feds. So why would he feel like he shouldn't call them related to these civil lawsuits? And the government's argument was, well, he should have known, I guess, is what the attorney said. He should have known. After what she said, you basically should have knew. But I mean, if, as people are saying, there have been several police reports in the past and nothing has happened to Diddy, then maybe he shouldn't have known. You know what I'm saying? Like little things, not necessarily this alleged sexual stuff, but they're saying like assaults and arsons and whatever else was in there and nothing happened. Maybe I guess he really didn't think that anything would happen. So anyway, in March is when he learned that he was under investigation. So let's go on. Defense counsel also rebutted the government's other obstruction and witness tampering allegations regarding a civil lawsuit filed against Mr. Combs on September 10th of 2024. After the suit was filed. Now, after this one, he did know he was under investigation because this is the Don Richard lawsuit. And he knew his house was raided back in March. And prior to his home being raided in March, his attorney tried to reach out to the AUSA to introduce himself. After the suit was filed, Mr. Combs spoke with an individual the lawsuit identified as a prominent witness to his alleged violence. The individual in question was very upset about publicity and wanted to make a public statement that her personal experience diverged from the lawsuit's allegations. As counsel explained, this witness was represented by an attorney at the time of the communication and could be an important defense witness with whom the defense will likely continue speaking. Counsel further explained that Mr. Combs had, quote, with counsel's blessing, quote, called potential defense witnesses to let them know that counsel would reach out to speak with them, end quote. Notably, search warrant affidavits disclosed to the defense on October 7, 2024. Apparently, this is probably under seal, so they redacted it. But during its proffer to the court, the government concealed this fact, and they're still concealing it now because, as you see, it's redacted, which completely undermines its claim that the timing of the contacts with the witness in September 2024 suggests obstruction. Although the government vaguely described contacts with two grand jury witnesses, it proffered no evidence of any threats or intimidation. The government could only state there were 14 total contacts between Mr. Combs and one witness and another witness who was contacted multiple times. Defense counsel explained these contacts involved no obstruction or witness tampering. For example, one witness contacted Mr. Combs, not the other way around. She reached out to Mr. Combs and told him, quote, I'm a grand jury witness, end quote. After Mr. Combs informed defense counsel, he was instructed not to contact the witness anymore, and he didn't. Of course, the defense explained it must, quote, continue to interview witnesses, end quote, to conduct a, quote, responsible defense investigation. How y'all feeling? Simple Me said, damn, Diddy might put up a fight. Hey, she said, hey there, everyone. Happy it's Tuesday. Nah, he knew. He thought he could still be slick. Little Lady QT said, thanks for all you do. Minx the Q said, this is a well-written brief as a paralegal myself. Thank you, Minx the Q. That's all I'm saying. I think she's a good writer. Jeez. Y'all getting mad at me because I'm like, I done seen trash briefs. That's all I'm saying. I think she's a great writer, and I think she's articulating and she's communicating very well in this brief. Celine Solange, thank you for the super chat. She said, in my opinion, the 922 can't be explained away. Thank you for your thoughtful commentary. Thank you so much for the super chat. Okay. We haven't really gotten to we heard these arguments already. We haven't really these are kind of the facts highlighting what happened in the bail hearing. And she's basically arguing that the court didn't basically paid their argument dust, even though the government didn't have rebuttals to a lot of their arguments. So for those that don't remember, Mr. Combs proposed a robust bail package with extremely restrictive conditions. In addition to the rebutting the government's proffer, Mr. Combs proposed a strong bail package. Prior to the district court hearing, the proposed conditions included a $50 million bond co-signed by Mr. Combs and 7 family members, secured by Mr. Combs' unencumbered $48 million home and his mother's home. Travel restricted to the Southern District of Florida and Southern and Eastern District of New York to attend court, meet with counsel, and attend medical appointments. Home detention with GPS monitoring. Providing Mr. Combs' passport to pretrial services. Retaining the passport of 5 other family members. Continue efforts to sell Mr. Combs' airplane and a restriction on bringing the plane to any district in which Mr. Combs is located. restricting all visitors to Mr. Combs' residence except family, caretakers, and friends not considered to be co-conspirators, with no female visitors except family and mothers of Mr. Combs' children, with the daily visitor log shared with pretrial services. No contact with known grand jury witnesses, weekly drug testing by pretrial services, all other standard conditions of pretrial supervision. During the hearing, counsel supplemented the package with the following additional conditions specifically designed to prevent any witness tampering or obstruction: 24/7 monitoring of Mr. Combs by a third-party security force, SAGE Intelligence, which employs former federal and state law enforcement officers, no access to the internet, no phones, restrict visitor access to only a pre-approved list of visitors to be shared with the government, pretrial services, and the court, and video camera monitor of Mr. Combs if necessary. In addition, during the hearing, defense counsel repeatedly made clear Mr. Combs would accept any other conditions the court deemed necessary. Counsel offered, quote, to put together a protocol so that the court is absolutely satisfied and comfortable that there is quite literally no way that Mr. Combs would be able to conduct any kind of contact, do anything with a witness of any nature. Quote, we can have any protocol that your honor sees fit. We can do whatever your honor thinks is necessary. The district court's ruling. So after Diddy's attorney offered to give everything, I'll give you this, I'll give you that. You take away this, you can take away that. I don't even got to be on the internet. What's the internet? I don't care. You can have an ankle monitor. You can have a video camera over in the corner watching my every move. You know how I was recording other people? Y'all can record me. And I will pay for somebody to monitor that doggone camera. I'll get a visitor list. You know what I'm saying? I have a visitor list. I can't go out of town and my kids can't go out of town too. I don't know why the kids got to be on punishment too, but apparently he threw the kids in. The mama's house was in there, so he done threw everybody. The baby Love is like 1 or 2 years old. She can't even go see Uncle Russ and Bolly. She can't go do nothing either because all the passports are just being held by his attorney. So he done threw everything up against the wall. And after he threw everything up against the wall, this is pretty much what the court had to say, okay? The district court said, it says the court denied bail and granted the government's detention request at the end of September 18th hearing, stating, this is what the court said: I find that the government has carried its burden of persuasion by clear and convincing evidence on dangerousness, both for obstruction and witness tampering, as well as danger more generally, even if the defense has rebutted the presumption by coming forward with their burden of production. The court stated it need not reach flight risk. So that's all the court concluded. The court further stated, quote, the government has proven by clear and convincing evidence that there is no condition or combination of conditions that will reasonably assure the safety of a person in the community, as well that Mr. Combs will not obstruct justice or tamper with witnesses. The court rejected Mr. Combs' proposed bail package and adopted the government's argument that under the proposed conditions, the defendant would still have access to employees and other individuals, and thus, quote, could obstruct justice and intimidate witnesses through those folks, through even coded messages if necessary. The court made no finding of fact and provided no further indication why it concluded detention was necessary. On October 3rd, 2024, the case was reassigned to Judge Arun Subramanian. So it has been reassigned to another judge. And people are speculating on that, but he just said it was a conflict, like he couldn't put it on his calendar. I think we reach and try to find every little thing. Like it has to be something sensationalized about how this happened. So typically the judge that you get, it's an administrative type of a deal where it's a draw. So whoever draws, whatever judge draws that case just gets that case. It's not like, ooh, you're a better judge, let's go to you. Or you trying to cut deals to get another judge. It's not like that. It's literally a draw. So Diddy's attorney made it clear that he wanted a speedy trial. And so this judge looked on his calendar and was like, listen, I don't know how fast I can do it based on my calendar. So it sounds like he stepped down. But I mean, everybody that made stuff up. You guys, Pam. Hey, Pam, do you think it's something nefarious about this, Pam? I'm like, it's kind of the process. Like it happens. It's not uncommon for judges to switch out. But hey, I understand. This is the thought process. Courtney said if Diddy gets bail, he for sure about to try and terrorize everyone involved and tamper with evidence. That's what Courtney Makeup-son. Diddy, I ain't say that. That was Courtney that said that. Willie J said, calling all crazy people, stop videotaping yourself, dummy. It's over 1,000 of you guys. If you guys could hit that like, that would be great. Let's go to the standard of review. So this is what the court has to, how they have to assess everything. Ruling of law and bail proceedings are reviewed de novo, while historical facts are reviewed for clear error. The scope of review is slightly broader with respect to the ultimate determination the defendant does or does not present a risk of flight or danger, whether conditions will reasonably assure the defendant's appearance and the safety of the community is a mixed question of law and fact reviewed for clear error. Let's see my phone. Hold on. Okay. One moment, please. Okay. And for those of you that don't know what de novo is, because I don't want to just assume that you guys know, their review, it's a Latin term, like a lot of our legal terminology is Latin, and it basically means anew, like from the beginning, fresh. You know, like they can look at it as if it's just, looking at it for the first time. Okay. Let's see. So basically, when I say, trying to make sure I'm clear on de novo, when I say it, they look at it fresh, they'll decide these issues based off of them applying the law that they know to the facts. They don't even have to really refer to what occurred, in the lower court and their decision. They don't have to take that into consideration. They can make their own decision. The clearly erroneous standard does not apply. If the court has made an error of law, in which case the court's findings should be set aside. If, for example, the court does not consider the factors set forth in 18 U.S.C. section 3142G in reaching its ultimate finding on the existence or non-existence of conditions, the finding will be subject to more flexible review. The court's finding will also be subject to plenary review if it rests on a predicate finding which reflects a misperception of a legal rule applicable to the particular factor involved. Wah, wah, wah. Let's go to the argument. So the first argument is the district court erroneously concluded that Mr. Combs presented a risk of obstructing justice and witness tampering. The court has held that clear and convincing evidence that there exists a serious risk of obstruction or witness tampering can justify pretrial detention. But there was no clear and convincing evidence supporting detention here. The circumstances justifying detention in prior cases were completely different, and the court's contrary conclusion reflects a misperception of the applicable law. First, the government's proffer concerning alleged obstruction and witness tampering was too thin to support detention. The proffer highlighted 2 points, uno dos. The March 5th, 2016 video and Mr. Combs' alleged contact with witnesses. Regarding the 8.5-year-old video, the defense's robust competing proffer explained Mr. Combs' decade-long consensual relationship with victim one, the video's context, and that both parties had subsequently participated in drug rehabilitation. And the witness contacts the government cited were minimally relevant or entirely innocuous. For example, the government emphasized that Mr. Combs had contacted witnesses, But these contacts were largely related to civil suits filed before the indictment, and most occurred before Mr. Combs even knew that there was an investigation. These communications, the substance of which the government did not fully disclose, hardly reflects threats, obstruction, or witness tampering. Even with respect to two grand jury witnesses the government claims Mr. Combs contacted, the government could only vaguely represent that there were 14 total contacts between Mr. Combs and one witness, and that another witness was contacted multiple times. That was it. The government provided no further detail, nor did the government share how these witnesses even perceived the contacts. The government's silence on this point is telling because the proffer was implausible on its face. While the government suggested witnesses have universally, one for one, expressed the prosecutors their extreme fear of Mr. Combs, extreme, at least one of these witnesses proactively reached out to Mr. Combs to tell him she was a grand jury witness. And once defense counsel learned Mr. Combs was contacted by a potential grand jury witness, they immediately instructed him to cease any such contact, which he did. Clear and convincing evidence requires that the evidence support the conclusion with high degree of certainty. The government did not meet its burden. The proffer provided no basis to believe Mr. Combs had threatened, intimidated, or otherwise attempted to tamper with witnesses and fell far short of demonstrating a serious risk of obstruction or witness tampering in the future. In this case, the defense's competing proffer adequately rebutted the government's allegation and at minimum left the evidence equipoise. Second, the court misapplied precedent. The cases the government relied upon are far afield. In Leon, for example, there was ample proof that the defendant had threatened two potential witnesses, including through explicit threats to his arresting officer that he would, quote, get even and, quote, see to it they went on a, quote, very long vacation. The findings of threats rested on strong evidence in the record, including witness testimony at the bail hearing. So they are distinguishing the case that the government used, and apparently it's this Leon case, and they're saying, our case is not like Leon, Judge. In Leon, there was ample proof that the defendant was threatening witnesses because they had him quoting saying, I'm going to get even. I'm going to get even. I'm sorry. I'm going to see to it that you go on a very long vacation. But Mr. Combs didn't do anything like that. We don't have any evidence that he's making these type of threats at all. So that's what they're saying. And LaFontaine was a bail revocation decision under 18 U.S.C. 3148, so a much lower burden of proof, probable cause applied. Even still, LaFontaine rested on actual evidence that while on bail, the defendant shredded documents, attempted to contact and intimidate witnesses, and lied in the affidavit to the court. The non-binding decision in U.S. v. Bankman-Fried likewise involved a bail revocation proceeding under the lower probable cause standard. In cases where the government proffer is as thin as the one here, the risk of witness tampering or obstruction is not supported by clear and convincing evidence. And it cites U.S. v. Stein. Although the district court never explained its reasoning, it appears to have erroneously adopted the government's exaggerated rhetoric. There was no factual or legal basis for detaining Mr. Combs. He is entitled to pretrial release. Are you guys more convinced now after hearing the facts being applied to the case law? Are you guys more convinced that perhaps the district court was like, nah, I'm looking at this stuff. I don't like this video. This stuff is looking egregious. So I feel like you just shouldn't be on these streets. Or do you think the district court actually did apply the facts pertaining to Diddy to these cases? What say ye? Okay, we don't believe you. You said not at all. Okay. Okay, Fly to Fit Chick said I am. All right. A Sunshine said it sounds like the government is using other cases to show a pattern of contacting witnesses. Am I correct on my assessment? No. So what happens is when you proffer your argument, you always have to have authority. So you use cases in order to bolster why. So I'm going to say, listen, I want my client. So for me as the defendant, his attorney should present cases that show people in similar situations were able to get bond. And this was why, or whatever. Maybe it's not a case on point, but you try to find a case that is as close to it as possible. The government is trying to show cases of which bond was denied. And what they're supposed to do as a defense attorney, what you just heard, is the defense attorney basically distinguishing Mr. Combs from these cases. So, for instance, although there are some allegations that he contacted witnesses, they're saying it's not like these cases, such as Leon, because in Leon, there was ample proof that the defendant actually threatened these witnesses. There really was no evidence that Diddy threatened or tried to coerce or do anything with these witnesses. It was just evidence that there was some type of contact. And his attorney is alleging this contact was because there were civil lawsuits. And so they were filed after the Cassie situation. And then he also alleges that some of these people, one of them at least, had got a grand jury subpoena and they contacted Diddy. And his attorney was like, bro, you can't talk to them if they've been contacted, if they've gotten a subpoena. So what his attorney is doing right now is he's distinguishing the laws that the government used, or the case law that the government used in order to bolster their argument for him to be detained. That's what their attorney is doing. And this is how you apply the law to the facts. And then, so that's what we have to do when we write briefs. I hope that answers your question. Minx the cutie said you have to put your objective hat on and follow the law. Personal feelings aside, the defense has a point. You have to remove personal feelings and apply the law. Exactly. You have to, and that's what I said in the beginning. You have to take your emotions has no place here. We have laws for a purpose. We have case law for a purpose, and you apply your factual situation to the law. And that's how you come up with the proper conclusion. But you do have to get case law or statutory law or whatever in order to bolster what your argument is. That's why I always say with everything, where is your authority? You always have to have your authority to back up whatever. You can say whatever you want to say. I can say, I think he should be detained. I can't just say that as the government. I have to give facts, such as he's threatening or coerce witnesses. People are scared. People don't want to come forward, whatever their reasoning is. And then I'm supposed to say, well, in United States v. such and such, the judge said because this person did the exact same thing, they were denied bail. So that's how you do your arguments as an attorney. Of course, Miss Buckeye, that's what I'm here for. I'm glad it clears it up, a sunshine. Guys, make sure you hit that like button as you come on in. Okay, let's go to point 2, the district. This is the second issue that Diddy is arguing in the appellate court. The district court erroneously concluded no conditions of release could suffice. Pretrial detention is permissible only if the district court finds, quote, that no condition or combination of conditions will reasonably assure the appearance of the person as required and the safety of any other person in the community. The court has an obligation to consider all possible alternatives to preventive detention. Whereas here, the court's ultimate finding rests on a predicate finding which reflects a misperception of a legal rule. The court's decision is subject to plenary review. And another thing about the Court of Appeals is it has to go based on the record from below. So you don't come with new issues, new arguments, and all of that. It's literally them reading your brief and your transcripts or whatever happened below. And sometimes they will allow you to have oral arguments, but you can't be coming up here with all type of new evidence and all of that. So that's why you hear them repeating the same things that were argued in the trial court, because that's what the appellate, it reviews the decision of the lower court. So whatever the government's arguments are, they're going to have to pretty much come with the same arguments. However, they may have better case law or something to support what they were arguing. Okay. The court erroneously rejected Mr. Combs' proposed bail package, which was plainly sufficient. The government claimed the proposed conditions, quote, do not speak at all to Mr. Combs' risk of obstruction, as they still contemplate him having staff and visitors. But counsel adequately addressed these concerns at the bail hearing by proposing additional conditions. These more restrictive conditions prohibited internet and phone access and included 24/7 monitoring by well trained third party security personnel and video monitoring if necessary. The proposed conditions reasonably mitigate any perceived risk. The Bail Reform Act expressly contemplates releasing a defendant into, quote, the custody of a designated person who agrees to assume supervision if the designated person is able reasonably to assure the judicial officer that the person will appear as required and will not pose a danger to the safety of any other person or the community. There is no reason 24/7 monitoring by trained third party former state and federal law enforcement officers could not prevent obstruction, particularly where the defendant will not have electronic devices and thus cannot directly contact any witnesses. Courts have found similar proposals sufficient to ensure against obstruction, flight risk, and danger in past cases. So one of the cases they say that this was sufficient was United States v. Williams, and it's a 2008 case. It is unpublished, but it is in the Southern District of New York. And in that case, it concluding that proposed conditions reasonably mitigated danger to community and risk of witness tampering because if a defendant is, quote, strictly confined to an apartment with electronic monitoring, there is no meaningful likelihood he will engage in any contact constituting a danger. They also cite United States v. Sabani, which is a Second Circuit case that describing a comparable package as, quote, extraordinary and vacating and remanding for release in stated conditions. They also cited United States v. Dreyer, and that's a Southern District of New York case of 2009, in that case, they approved a similar bail package. So, like I said, they're not just requesting it just to be requesting it. They're trying to show cases that are, I guess, similar to which they've allowed the same type of bail packages. The district court rejected the proposed bail package for purely speculative reasons. The court stated the proposed conditions would permit Mr. Combs to, quote, obstruct justice and intimidate witnesses, end quote, through, quote, employees and other individuals and even coded messages if necessary. There was, however, not a shred of evidence that Mr. Combs had used third parties to tamper with witnesses through coded messages. Nor did the government cite any evidence supporting its bald claim that Mr. Combs used intermediaries to reach out to people. Instead, their proffered example involved a direct contact, one that occurred in November 2023 when the only pending proceeding was a civil suit. The government alleged that after victim one filed her lawsuit, another alleged victim, also a girlfriend, initiated contact by texting Mr. Combs, who subsequently called her and recorded their conversation on another person's phone. So whoever the other second person who called him, they're saying that was his girlfriend too. That's interesting. This didn't involve an intermediary and is hardly evidence of obstruction, even apart from the fact that Mr. Combs could not have contemplated any particular official proceedings at the time. And then there's a footnote of another case, Arthur Anderson v. United States, where it states that requires nexus between the obstructive act and the proceedings. And then there's another case, US v. Aguilera, which requires knowledge that one's actions will affect pending grand jury proceedings. Why would a person engaged in witness tampering record the conversation? That's what his attorney said. But some people want to know, why would you record all these acts too? So, He was obviously recording the exchange to protect himself from further false accusations. I promise y'all I ain't read this before. Whew. He recorded the phone call to protect himself. So it has, even apart from the fact that Mr. Combs could not have contemplated any particular official proceeding at the time, why would a person engaged in witness tampering record the conversation? He was obviously recording the exchange to protect himself from further accusations. So he recorded that phone call. The court would look incompetent in reversing course. Now, were these other cases defendants nearly billionaires? His bank accounts gives him broad reach. I have not read these cases at all. Thank you so much for the super chat. I'm just reading the brief. That's it. So I haven't gotten that deep to see, what the facts were behind those specific cases. But Kiss a Moose said, how can they outright lie in the briefing? What do you say? What do you say that they lied about? What specific lies are you referring to? Let me know. Bobby said, y'all in this baby oil. I know. It clearly wasn't because of what his attorney said that Costco's, they just bought it in bulk, because Costco's was like, don't put us in it. So, Bobby, I don't know. We'll probably never know. Miss Buckeye said, you make understanding the law of the land easy. Thank you. I appreciate that. Thank you for the super chat. You know what Maggie said? He probably records himself busy. Y'all are funny. Aaliyah said Diddy did tell someone he would take care of their rent or something. Yeah, I heard that too. I'm sure whatever the specific statements were, when the government responds to this appeals brief, they're going to refresh everyone's recollection on it, whatever the conversation entailed. But as you guys see too, with text messages, the ones that were here last night over the Garth Brooks situation, sometimes text messages, unless you have the whole context of them, they can be taken out of context as well. So hopefully they come with the entire conversation so that we can know the complete context of that conversation. You said that he wasn't aware of the case when he was in. No, I think they were saying that he wasn't aware he was under investigation when he went to New York. He moved to New York when he found out that the indictment may be pending. He knew he was, this is according to counsel, or his, according to this brief. He knew in March that he was under investigation. Of course, by the end of March, I think it was, or maybe April, around that time, there was a warrant to search his homes. So his homes were searched, his business was searched, his airplane was searched, all of that happened. However, he did not know that an indictment was going to come down. He did not know that until a couple of weeks before the indictment came down. And that's supposed to be why he moved to New York, was because he knew the indictment. Because just because, like Mayor Adams said, they have been investigating him for years, but nothing came from it. So just because they're investigating doesn't necessarily mean they're going to indict you. So once he knew that they were going to indict him, and his attorney received words like, oh yeah, they indicting you, bro, then he moved to New York so that he can be available. But I think he wanted to turn himself in. And the feds was like, no, when they did not allow him to turn himself in, that's when I knew that the government was going to fight him on bond. And I said that on here. I was like, oh, they came and arrested him? Oh, nah. They're going to fight for him. They're not going to let him go out on bond. like a Bill Cosby, because I think Bill Cosby was out on bond. But it did. It did. Lisa Fleming said, "Hi Pam. If he was released on bond and they add more charges to him, could they then rearrest him? They have to. He's gonna have to stand there again and plead on his new charges. He has to go through a whole arraignment if they do a superseding, and then they'll decide whether they're going to continue to bond or if they're going to try to go through the bond thing again. If he's out on bond, if they give it to him, then they'll have to decide whether they're going to continue to bond. I would suspect that the government would use that as another reason to fight and say, nah, he got more charges and it's more people and it's more serious or whatever it is, and then try to revoke whatever the bond is." Sonia Mila said, "Did you guys see the guy who worked on a Tubi reality show with the girl who was humping Diddy and Kevin Hart at the same time this year? Diddy and Kevin called and threatened them, and all co-workers warned." I did see that video. I did see that clip. It was on TikTok. Yes, it is all alleged. Yes. They will give you a heads up that an indictment is imminent. The government does give you that courtesy. Yes. You don't know when, but they'll let you know. And then, of course, he kind of knew because grand jury subpoenas were going out. So, and when it goes before the grand jury, for those of you that don't know, the defense is not there. It's a low bar. That's why they say you can indict a ham sandwich. That's the ongoing joke. But of course, the federal government usually doesn't bring cases unless they know they can win, because they like to win. But it's not anything where the defense is there where they can cross-examine and object and all of that. It's not like that. It's literally the government gets to put on their case, and then the grand jury can decide whether it's probable cause to bring these charges against them. Yeah. Oh, God. Now I gotta block people. Y'all watch the chat because it's like spam coming in here for the mods. Usually we pretty smooth sailing. We just tell y'all to hit the like and subscribe, and we thank everybody, and we all one big legal family. But sometimes we get some imposters that come in here and they do try to, disrupt it and spam our chat. So all right, let's go on. Regardless, as a practical matter, the conditions are sufficient to alleviate any purported obstruction risk. The proposed package contemplated a pre-approved visitor list, and counsel made clear it could be further limited in any way the court saw fit. The only necessary visitors are members of his defense team, who obviously will not be assisting any efforts to obstruct justice. To the extent family members are approved for the visitor list, security and visitor video monitoring is sufficient to ensure against the purported risk of an attempt to indirectly contact witnesses. And then there's a footnote that says, since there was no history of code messaging, there is zero risk of Mr. Combs using such code under monitoring. How would any visitor even know how to interpret the supposed code? Using a code requires a prior understanding of the meaning of any coded terms. The same would be true if employee visits were contemplated, but to be clear, there is no need for concern about employees and friends and the like. Mr. Combs will not request that any employee or friend be permitted to visit him, nor would it be necessary for him to speak with employees. Mr. Combs, this is footnote 3, Mr. Combs would also consent to home detention within the district if housing can be arranged. So apparently, he will stay in the Southern District of New York if somebody says, Diddy, we'll rent this space for you. For such conditions to be adequate, the act requires only a reasonable assurance and does not demand absolute certainty, and that's U.S. v. Austin. To require the latter and deny release on conditions based on speculative doubts could only be a disguised way of compelling commitment. Indeed, this court has already rejected the theory that certain, quote, conduct is so extreme and aberrant that no set of conditions could reasonably assure the safety of the community. That's US v. Mattis. Here, the conditions proposed were adequate relative to the weights of the purported risks. Mr. Combs should be released because, regardless of the government's untested allegations, the proposed conditions will reasonably assure his appearance and the safety of the community. The district court this is the third point. This is the third issue brought before the Court of Appeals. The district court erroneously failed to make factual findings and weigh the required 18 U.S.C. Section 3142 factors. The Bail Reform Act statutorily mandated procedures represent Congress' careful delineation of the circumstances under which pretrial detention is acceptable. Failure to follow these procedures or reliance on an extraordinary inquiry constitutes an error of law. The district court committed legal error by failing to make any factual findings or weigh the required factors. The act unambiguously requires written findings of fact and a written statement of reason for a decision to detain. This requirement is specifically designed to further the accuracy of detention hearings and is intended to ensure that the district court's reason for its decision are sufficiently clear to permit meaningful appellate review. The act further states, court shall take into account 4 factors in determining whether there are conditions of release that will reasonably assure the appearance of the person as required and the safety of any person and the community. The factors include the nature and circumstances of the charges, the weight of the evidence, the defendant's history and characteristics, and the nature and seriousness of any danger to the community. These factors ensure the act is administered consistent with due process. Thus, the district court must consider the factors, as the ultimate finding properly can be reached only after their consideration. So they're saying there are factors. They're telling the panel there are factors here, and the district court failed to weigh these 4 factors. In the cases the government relied on below, the detention orders were supported by detailed factual findings and explicit weighing of Section 3142G factors. Then it has a bunch of cases which we're going to skip. In contrast, the decision here reflects a wholesale departure from the Act's requirement. The court made no factual findings and failed to weigh the statutory enumerated factors. Although robotic incantations are not required, it is not at all clear what facts the district court used to support its decision, nor is it clear what evidence, if any, the court credited, why or on what basis it rejected the defense's offer rebutting the government's claims, or how it made its ultimate determination. The absence of such findings is particularly troubling here because the government proceeded largely by proffer, simply stating in the most general and conclusory terms what it hoped to prove. Although courts may rely on proffers, the existence of the discretion should reflect an awareness of the high stakes involved. But here, the district court took no additional steps to ensure the reliability of the evidence, and that's in LaFontaine. And because counsel contested the government's version of events with a competing defense proffer, the evidence was at minimum in equipoise. Without meaningful factual findings and weighing of the evidence, the detention order lacked any basis. The court has reversed similarly defective detention orders, and that's in U.S. v. Friedman, which vacated and remanded where detention order contained only implicit findings relating to risk of flight and no finding whatsoever on obstruction. In conclusion, we have made it to the end. Yay, we have made it to the end. For the foregoing reasons, the district court's detention order should be reversed. The court should order that Mr. Combs release under the conditions proposed below or any additional conditions the court deems necessary. And that is it. What do you guys think, huh? What do you guys think here? I think it's a good brief. I think they have plausible arguments. Now, whether the Court of Appeals feels like it's enough, you know, because I'm sure there are cases out there. Again, I haven't researched. This isn't really my case, but there may be cases out there that the government has that may be more akin to this case as to why they feel like that he should not be out on bond. So we'll see what their response is. But I do think it was a well put together brief. I think they did have some valid arguments in it. It wasn't just, all fluff. I think they had some valid arguments and concerns, especially if you don't really have evidence of him threatening and coercing people or whatever. Because with civil lawsuits, let's be clear, what if he was trying to settle? He settled with Cassie. I mean, that's kind of what it is. You do have conversations. So I can kind of see that argument. Now, I recall the government making an accusation, which I'm sure will be in the response, of which they were saying that with this former girlfriend, I guess who she was, he found out, noticed her name in a pleading or something, and contacted her. And when he contacted her, he was trying to, according to the government, of course, we didn't hear it, the conversation sounded like he was trying to get her to confirm that they were in a relationship, that everything was consensual. If you need anything, I'm going to pay for your rent, as Aaliyah was talking about. So that's maybe they're trying to use that as if it's some type of bribery or whatnot. I don't know. We just know by how the government is interpreting this alleged phone call. We didn't see a text message that I recall, and we obviously didn't hear any recording, so I don't know. Nikki said it was well put together, but I think the government is about to drop the hammer with evidence, even if they just pulled up phone records and he did call her instead of her calling him. Well, it's only so much that they're going to be able to put in this brief because, again, as I was explaining, this is the Court of Appeals, so they look at what the arguments and everything that happened below. Because I'm sure this attorney probably would have added more arguments if they could, but this is an appellant brief, so you have them look at everything that happened below. So they're going to have to maybe elaborate on the arguments they already had, but they can't be trying to come with no new evidence to throw in there because it has to be what the lower court based their decision on. And then if they got it wrong, that's what the Court of Appeals is for. Passport Shogun said he's not a threat. They should release him. One said, but didn't he pay the hotel? And I'm sure there are other payouts in the initial filing. Why would they let him out on bond? Okay, so the hotel situation was back in 2016. Clearly, he was not under any type of investigation when that happened. Thank you, Cecile, for the super sticker. I appreciate that. And they're labeling that, of course, as, like they said, the government gave a proffer of their definition of this situation, and the defense gave their proffer of their definition of the situation, which is that there was a relationship and it was toxic. And even though domestic violence obviously is not an acceptable thing, there are several people that are in toxic relationship and domestic violence relationships. And he's saying he was in this relationship over a long period of time and that they were on drugs. I know all of this stuff coming out about Diddy where he has to kind of be vulnerable, where we have to see, like, you really, people were idolizing you, but you sound like you was kind of miserable. You had to take drugs every day to cope. You was drinking all the time. You was disrespecting, it sounds like, your body, because you can disrespect your own body. You were doing, like, people always want to say somebody is goals and that's who they want to be like, but you never know what their life is behind closed doors. You got all this money, but nothing still seemed to matter. Like nothing seemed to be get you to that point of having joy or being happy because you was doing too much. You blowing up cars allegedly and getting mad and people breaking their houses. Like you was just doing too much. Like, but you look like you had it all. Look like you had it all. That's why people have to be careful when they start envying people, especially on this here internet. Miss HLS said he needs Jesus. Man, listen, fulfillment void, yeah. Well, when you abuse or wrong other people, you might be miserable. And also when you've been abused and wrong other people, you may be miserable because there are a lot of people that do things to other people that what was done to them. A lot of predators were preyed on. A lot of people that were abused, that are abusing people, they were abused. They mimic what they saw or what happened to them. It's not an excuse because I feel like once you become an adult or when you take responsibility for yourself, and if that means therapy and medication, you go get it. But he suffered from a lot of stuff mentally, you can tell, because you gotta stay drunk and high all the time. Like I think they said what when they arrested him, perhaps it was drugs or something there allegedly. Mm-mm. Power dynamics said we shouldn't worship. So absolutely, absolutely not. Mm-mm. We should not worship celebrities. I agree. Or people that be couple goals, because most of them they just try to do it for the internet. Relationships be trash, and you sitting up there praying to be like them, and then you wonder why your prayer get answered, and then the man or the woman you win is garbage because you're sitting up there trying to pray about trying to have the same relationship with somebody who's faking the funk for the internet. Courtney Makeupson said the documents sound like lawyers are stating they don't understand this and don't understand that about the court's conclusion. If I was the court, I would respond and give them answers they're looking for. Well, the court can't do that. So the court gave its conclusion. They basically generally said that they don't believe that there was clear that they felt like the government's argument was more compelling and that bond wasn't, they didn't really elaborate. I mean, we went over what the conclusion was, and so that's what the defense is saying. You didn't really come to a reasoning as to why you came up with what you came up with. I mean, I can appreciate the zealous advocacy that Diddy has going on right now. That's all. David said P Diddy is a okay. All right, David. No arguments here. Sonia said Hugh Hefner, Jeffrey Epstein, Bill Cosby, R. Kelly, now Diddy. So no, he deserves a trial, but keep victims and witnesses safe until trial. In my opinion, hey, when is court? So Diddy actually has something this week, I believe. It might be tomorrow. I think he has something on the 9th. I don't know what it is. I can't remember. But this is in the Court of Appeals right now. This is the Second Circuit. So it's in the Court of Appeals. And so what happened is they have briefing dates of when the government has to respond. And then, either the court may make a ruling based on the pleading. I don't think this was I don't know how fast they get to bail. It probably is faster than a regular appeal on a case or on a trial, I would assume. So the government will respond and we'll see what their response is. I'm sure a lot of you guys will be rooting on the government, but the government will respond and then we'll get an opinion at some point. I don't know if they'll have oral arguments or not. That's up to the Court of Appeals. Whitehead's homeboy. You talking about Eric Adams? So Eric Adams, he did have one of his closest aides was indicted today, I think for obstruction of justice. What was his name? Abdul somebody. I think his name was let's see. Mayor Adams. According to the AP, a former New York City official was charged Tuesday with witness tampering and destroying evidence in a sweeping federal investigation that led to Mayor Eric Adams' indictment on charges he took bribes and illegal campaign cash from foreign interests. The arrest came amid an ongoing exodus of top Adams administration officials as federal prosecutors delved deeper into allegations that the mayor was using staffers in an attempt to cover up wrongdoing. Mohammed Bahi, who resigned Monday as the mayor's liaison to the Muslim community, is accused of encouraging a businessman to solicit illegal straw donations from four of the businessman's employees and to then lie about it to the FBI. At one point, Bahi told the businessman that Adams believed the man wouldn't cooperate with law enforcement, according to prosecutors. As agents arrived to search Bahi's home in July, they say he deleted an encrypted messaging app from his cell phone that he had used to communicate with Adams. Speaking at a news conference Tuesday, Adams denied that he had any hand in telling anyone to lie. Quote, I would never instruct anyone to do anything illegal or improper, he said. So basically, Adam said if he did it, it wasn't at my direction. Was it me? And then I remember him saying, Adam saying also today when they asked him about it, of course, whenever he does any type of press conferences, it's all about these indictments, people stepping down. A lot of people have stepped down. I think he's had 10 people step down. They're calling for his resignation. The governor actually has the ability to start that process. He said he's been in contact with the governor and they have a plan on replacing these people. But he basically said, I'm trying to run the city of New York and my attorney is handling that criminal process. And that's what it is. And the same thing with this staffer. He said he was a good staffer. You could look at all the things he's done in the Muslim community and how he's, helped the community, period, and let his attorneys also take care of him and defend him. So that's what Mayor Adams had to say. So, Pam and her law and order were doom doom. Nikki said that sounds serious. Lord, I couldn't commit a crime. It just sounds like too much. Yeah, I'm gonna need you to stay on this side of the law, okay? Cece said, Pam, do you think Diddy should get out? I personally do not think it is safe. He still has too much money, power, and access. I think that if the law, if according to statutory and case law that he should get out, then he should get out if that's what the law is. If again the government comes with whatever information and they come with cases that say he shouldn't get out, then he shouldn't. I think it's just something that should be properly evaluated and weighed. And it should not be based on emotion. Because, like, when he did go before the judge, I read the tweets from the person that was in the courtroom on Twitter, and the judge was like really into those tapes. Like, so that was love. What's love got to do with it? She was making those statements. I think she was about appalled when she saw that video or when they talked about the video of him stomping Cassie in that hallway. So perhaps they're making it seem like, it wasn't really a clear legal analysis. And after a clear legal point and analysis, it may be that he shouldn't get out. I don't know. But I do believe he deserves due process and he deserves a zealous defense. That I will stand by. He is presumed innocent right now until proven guilty. Everything that we have is speculation or what people are saying, or we're trying to be our own detectives. Oh, yeah, I remember in 1999, he was on video with such and such, and she looked really uncomfortable. Did you see the way she was looking? Now we're looking at every video, every picture, every article, every interview he's ever done, and we're looking at everything different. Like I seen the Justin Bieber interview where they were both on there, and they asked him about him buying him a car or something, and he was like, he knows everything that happens with Big Brother, Big Brother Diddy. You don't tell. You don't tell what goes on at Big Brother Diddy's house. And everybody's like, oh, that was evidence right there that something was going on with Justin Bieber. Like, we're looking at everything with scrutiny, but we really don't have the concrete evidence yet. So we have to sit back. And that's what I'm trying to get you. It may be that everything out here may be true. It may be half of it's true. It may be half of it, we don't know. So that's why I'm saying we just have to have an open mind. It's going to be interesting to see how long it takes them to pick a jury in this case, too. So, yeah. Petty Patty said, Pam is truly an officer of the law. She felt sorry for Nesta. I just... From the legal perspective, I don't feel sorry for him like what you're, like that. But I'm saying I believe if you're going to win a case, win it fair and square. That's what the problem with YSL is. To me, there's a lot of you're not giving over the information to the other side. You're getting witnesses at the last minute, not telling them. You're upping your list from 100 witnesses to 200. Like, how can you adequately defend your client if you're playing these type of games? I feel like if you're gonna win fair and square. That's what it is. If you're gonna take me to the mat, then let's be even. You get your expert, I get my expert. I know your witness, so I know how to discredit your witness. You come with this information, I'm coming with this information because I know what you're coming with. We are not an ambush system. It's no Matlock moments where all of a sudden Matlock's about to lose the case, and then all of a sudden lady comes that they thought was dead, and she just walks in like, I'm going to testify, and then just walks up to the front and goes on to the bench. That's not how we work. But that seems like how it's happening over there in Georgia. We're not an ambush judicial system. We're not. I'm supposed to have access to everything that you have. Now, what they will try to do is give it to you at the last minute and kind of overwhelm you. So maybe you can't look at all the evidence, but you're entitled to. You're entitled to review everything. You're entitled to be able to fight zealously for your client. And regardless of whether we can't stand the person, we don't like them, they wouldn't sit at our dinner table on no day, they still deserve a zealous advocacy. Passport Shogun says, speaking from experience, it's impossible to fairly prepare for your trial if you held in jail. I believe that. I couldn't imagine that. I've never had that experience where they're in jail and that's the only way you can prepare. Grace, Mercy, and Save said that only happens in the movies. Yes, but a lot of people think that's how it works. You said, oh, the new Matlock is so good. The first episode is on YouTube. I didn't know they had a new Matlock. That's interesting. Diddy did himself, and if he really recorded all those people who records their crime. That's what I'm saying. I just don't want to. I don't know. We're gonna sit back and we're gonna see. But that's the argument. I know that somebody asked me, they thought that the Court of Appeals attorney, Shapiro, had left the case or something, but she wouldn't be in the lower court, district court, because she's the appellate attorney. So all she did was file a notice of appeal so that the district court knows, but all your filings go to the Court of Appeals, which is the Second Circuit. So you have to go to their docket in order to get the information related to the appeal. So she's still on board. For always, forever, for life said, at the end of the day, I can't stand Diddy, but everyone is entitled to a fair trial. In my opinion, I feel if he got out on bail, he will be dangerous according to the video of him and Cassie. That's fair. Anything but predictable says, saw a video today with Mark Curry, a former bad boy artist, and he knew about the spiked drinks and he was laughing about it. You know what? A lot of them that I noticed tell these stories, they all have a little giggling behind the stories. It's very, very interesting. And I know with Mark Curry, he was like an artist that felt like he was shelved or whatever. I don't know if he felt blacklisted or whatnot, but I know he's out now. I see him in the studio trying to record at his big age. Yes, he's trying to come out and he had a book as well that's been out for a while, but now because the stuff with Diddy, he's trying to push his book because of what happened with Diddy. So yeah, thank you, Petty Petty. I appreciate that. Maria Moore said, if you are taking drugs, you are not in your right mind and you think you're invincible. Bobby said, in my opinion, the Cassie video isn't about emotion. If, according to the defense, it was an argument fueled by substances, what would he to people who might be the reason he goes away for life? Okay, that last sentence, I don't, you have to rephrase that a little bit. If, according to the defense, it was an argument fueled by substances, what would he do to people? Maybe do to people who might be the reason he goes away for life. What is he gonna do if he's in prison? I guess if he. No, that's you 504 talking about cutting that. Dang, we've been on here for 2 hours. Good gosh, you guys. I didn't even know we were on here this long. Just out here chit chatting and yapping. Didn't even realize that. All minds clear. Do we have anything else? Any other questions about anything else that we have discussed today or on yesterday or anything that is trending today in the news? Hey, T. Gabriel, you said, good evening, Pammy Pam. I commented on your live 2 weeks ago. Diddy is done. Regardless of the outcome, people will never look at him the same. I agree. It's going to be very difficult to savage that type of reputation because even if hypothetically he gets off on every single charge that the government throws at him, who is really going to be out here trying to support Diddy? Because you can't take away the Cassie video, all the things that she said happened, all I guess his alleged jealous rages that she said in the complaints. She gave specific times, dates, locations, names, and then eventually it was corroborated by that video. So we have no reason not to really doubt her. Some of these other ones is a little suspect, but with Cassie's, I tend to believe a lot of things she said was accurate. Um, but yeah, I think that he's going to be looked at just as a different person. We also have to we were talking about that over on W Worth TV. That's Nikki Gilbert from Brownstone. Like I'll post it every now and then. So I post it on my wall whenever I go over there and get in the chat trying to give, help her out over there as well. She's from Detroit. She was talking about yesterday the kids and how nobody really thinks about how it affects his kids. And I know some of the boys were around him like that, but his girls, like how is that affecting his girls? And we don't really consider that. So I just try to consider all aspects of this case and try to be fair, you know. Course correction said, and he was allegedly taping people without their knowledge who in the industry would want to hang with him. I wonder where his video cameras were, because like the cameras in most of the houses I've been in, you kind of see them. You know what I'm saying? They like in the corner of the kitchen. You see one in the, see one outside with the ringtone. Usually, if they got them outside, they got them on the garage. They got them whatever. And in your house, you'll have them as well. So I'm wondering, did they not know there were cameras? Were these cameras like surveillance cameras, or were these like cameras where it was like a hidden camera in a stuffed animal or something? That's why I said this is how my thought process goes. I need more information. Spring Flower said he won't care how people see him as long as he's a free man. That is a true statement. I think right now he can give 2 F's about public opinion. Right now he just wants to be free. That I agree with. Even though people are like, well, he lost in the court of public opinion. Yeah, he doesn't care. He's trying to win in the legal courts. That's what he's trying to win. Hey, Michi too. Good to see you. Yeah. We about to adjourn this night court in a minute. Let's see what you're saying. Diddy destroy generational wealth? What are those kids gonna do now? Isn't that is yeah, anything but predictable. Yeah, what how it's going to be a big lifestyle shift. Like when Diddy talks about, oh, if I go home to Miami, the only people to be there are my staff. Even the staff that work. Like, what are y'all doing right now? Like, did they have to go get new jobs and stuff? So you have staff that cooks for you, cleans your yard, clean your houses. It's videos of Diddy getting massages. Like, that's a whole different life. And now you got to figure out. I mean, they not starting from the scratch. Like, it's not like they starting from the bottom, but it's gonna be a shift, I think, in how they live. Like right now, I guess they're staying with their mother's friend or something in Cali, but not Walmart is hiring. It said, "Welcome to my world." Courtney says some people love saying, but he's a dad. What about his children? Why wasn't he thinking about being a dad when drugging and essaying people and recording it? That is alleged, Courtney. That is alleged that these people were drugged and were being abused. But I get what you're saying. And I don't think we have to compare. There's going to be a lot. When people go to prison, it doesn't just affect the person that goes to prison, it affects their family too. And we can't negate that, even though obviously there are victims. You have a lot of losers when crimes are committed. You have the family who wants to see, even with the Wade Wilson, if you guys have watched that scenario of the psycho over there who just decided to unalive a couple of people when he ended up getting sentenced to death, basically. Um, his father, like in the video calls, you can see the gut wrenching. That's still his dad. Like, who wants to see their kid? Or like, I still see you as the little baby that came out of your mom, and I was holding you on my chest. Like, yeah, it's going to be a lot of losers in this situation, and unfortunately, it may be based on the choices that were made. But that doesn't take away that his kids have suffered. They can suffer. The victims could suffer. The victims' kids could suffer, because I can't imagine if this did happen, how it affected them in their life and their relationships and their relationship. They're probably overprotective of their kids, don't want them to go outside. You never know. It is reported that he is 140 million in debt. Oh wow. It may be passport. We don't know. For always, forever, karma is real. He got the money by not paying others their due, so he may lose all the money that he stole. I hear you. My son is a teen with a deep voice, and I still hear his baby squeaky voice and see a baby. That's from Keonce. I think we all do. Most of my kids are adults, and I'm still worried. I still want to know where you are. I still like, you're still my baby. I don't care, even if you have babies. You still my baby. So I get it. Yes, grace, mercy, and say it's sad all the way around. I agree with that. So yeah. Brandy said Diddy's girls are taken care of for the rest of their lives. He set that up for them when they were babies, and I don't believe anyone can take their money. Well, we shall see. Brandy New School sings, we shall see, because one of the things in the indictment is they are trying to incorporate that all this stuff was happening. And the money that he got, even from obviously record deals and all of that stuff, were somehow shifted to third parties. So they have a provision that even those assets shifted to other people can be subject to forfeiture. So they do have hearings, of course, to if somebody wants to contest it and say, no, that's my money. That ain't had nothing to do with that. Don't take that. That was my money. Because that's what Kimora had to do with her husband, Tim Lessner. Well, they tried to take everything, and Kim and Kimora, Russell, a couple of other people, they all took dibs to it and said they're entitled to it. So Fine 9J, that's a good question. I agree. Sonya Mila said, I wonder who the guardians of the twins are. Isn't Kim the twins' mom? Sad. I hate this for the kids. Well, right now she's with they're supposedly again, I don't know these people, but according to reports and rumors, they're supposed to be with one of Kim's friends in Cali. Kiss a Smooch says seed money was cartel money, so y'all getting forfeited allegedly. That's what I'm saying. I think they made it clear in the indictment that they may take things. So even if you bought your mama a house with that stuff, your mama might not have a house. That's partly why I think they weren't impressed by him putting up that house, because they got a forfeiture clause. So if they actually find you guilty, if a jury finds you guilty after they put on their case, they're gonna take the house anyway. So it's nothing you can really give us. It's kind of what it sounded like to me. But who would contest that their mom is not living anymore? I didn't know they could go after child's trust and fund money. They would, anything that they try to forfeit and put their hands on, if somebody says that it's theirs and it's separate and apart, they can go after it. Somebody, I'm sure the twins probably have a lawyer. Somebody would do it on their behalf. Worldwide Collaboration said his lawyers and his mama's gonna make the feds break bread and start showing tapes like they leaked the Cassie tape. They're going to have to learn. They're going to have to stop challenging the feds. Yeah. What if he had the money and his kids' money in an irrevocable trust? It don't matter what they got it in. It doesn't matter. I'm not saying they're gonna take it. I don't want to make it like that's what I'm saying. I'm just saying, in my opinion, based on the reading of the indictment, nothing is safe. And it may be people that have to fight and say, this is mine, this belongs to me, and I want it back. You know what I'm saying? Don't take my stuff. Listen, I get what y'all saying about him, but like his mama could be like, I work for this company every single day. I earned this money for this house. You know what I'm saying? Because they're not going to come after royalties from Mace or something like that. But so that's why I said it's just going to be very interesting how, as this goes on, how this gets dissected. Well, goodness, you said he can give his life. He already lives here. Well, goodness, the gold experience. Okay. Yes, that's pretty much what I said. Because the criminal case is going to be done before the civil case. I'm pretty sure. Scorpio chick said this is just a mess. He should have sat his arse down somewhere. Well, Carisha, poor Carisha. She was up there at the BET when he was getting the Lifetime Achievement Award, throwing up signs and stuff, calling him Pappy and all of that. Now she's like, damn, what I get myself into. But yeah. All right, y'all. We about to get on out of here. As always, it's been fun. Thank you guys so much for the support. Hit the like button if you haven't done so on your way out. Of course, when the response come or anything else that comes down, we'll be on it. If you guys don't follow me on Instagram. That's where most people DM me about whatever they want me to talk about. I may hop on at any time, depends on what my schedule is for the day. As you see, it's been later on the last couple of days because of the way my schedule has been during the day. But it's Pam ESQ. I'm also on TikTok, even though I should post way more than I should. But I'm also on TikTok at Pam ESQ as well. Again, make sure you subscribe to the channel. Tell your friends and family that we are the Law Intellects. You guys have a good night, and I'm going to talk to you later.